Let's switch gears and talk about contracts. Okay. Big chapters here. You really want to spend some time in contracts. Now, you're going to see two terms, executory and executed. All right. Executory means it's unfinished. A purchase agreement, although it's signed, offered, and accepted, it's still not in an executed format. It's executory because when a contract becomes executed, it's not when it's signed, it's when it's at the closing table and the deed transfers. Remember, the deed is the byproduct of the contract. So the contract is executory or unfinished until the deed transfers at closing. Okay? Keep that in mind. A valid deed means it meets the legal system, all essential elements, and it's enforceable in the court of law. A verbal, listen to me carefully, a verbal agreement, also called a parole contract, P-A-R-O-L, you may see that on the state exam, does not meet the statutes of fraud. The statutes of fraud, by definition and in theory, means that a contract to be enforceable has to be in writing. Okay? How can you enforce a verbal contract if two parties don't agree to it? There's no proof. It's not on paper. There's no signatures. So verbal agreements are unenforceable unless the parties agree to it. Right? Judge Judy goes through this every day. She goes through this every day. Right? She's looking for something. She calls it the four corners. That's what she calls her contract. But she can't enforce something that's verbal. It's a verbal agreement. Okay. So you want to know executory, unfinished. Talking about real estate contract, unfinished. But John, it's signed. It's accepted. It's a valid contract. Yes, it is. But it's still executory because it doesn't become executed until the closing's done. Remember, that closing is indicative of the written agreement that you signed. So if you never transfer the property, that contract's never executed. Okay? Keep that in mind when you read the question. Valid contract meets all essential requirements. It is legal and enforceable in a court of law. Verbal, also called a parole contract, doesn't meet the statutes of fraud, which means a contract needs to be in writing to be enforceable. Verbal agreements aren't enforceable. So you may get a test question. A verbal contract for the sale of a home is to be completed tomorrow in writing. Right now, the contract is what? Okay, good. Excellent. Looking for the key words, verbal. But wait, John, it says it's going to be completed tomorrow in writing. Has it been completed in writing yet? No, still a verbal. So right now, it's not tomorrow yet, but right now they're saying it's still unenforceable. Okay, very good. Awesome. All right, continuing on. I like this memory aid called Cold Ice. Cold Ice. This is what makes a contract valid. These are the required elements to make a contract valid. You got to have contractual capacity, which is legal age, sound mind. Okay. Got to have meeting of the minds or offer and acceptance, CO, offer and acceptance, signatures. It's got to be legal. Okay. The purpose has to be a legal contract. The real estate contract has to have a description or a legal description, an accurate legal description, not a mailing address, although it'll be on there. But for it to be a valid contract, you have to have a surveyed legal description. Okay. It's got to be in writing, according to the statutes of fraud. We just discussed that about verbals. And then consideration means you're exchanging a home for the value of the home with money. That's called valuable. If it's a good consideration, then it's a donation. It's humanitarian. Okay. So you want to know what your essential elements are to make a contract enforceable in a court of law. Cold ice, contractual capacity, offer and acceptance, legal or legality of object, description, legal description, in writing, and consideration. Okay. You want to know this. This is a good memory aid. You got another technique that your school taught you? Go with that. All right. A requirement of a valid purchase agreement is, and you got to read the question, a requirement for a valid legal or a valid purchase agreement. What's required out of these? Excellent. Yep. Offer and acceptance, part of your cold ice, right? Contractual capacity, offer and acceptance. Okay. You got to have signatures. Don't necessarily need earnest money or time is of the essence. But for a valid contract to be established in a court of law, be legally enforced, out of these 4 selections, you have to have offer and acceptance. You have to have buyer signature and seller signature. Okay. Develop a system where you have memory aids that will trigger you when you come to test questions like this. Because when you come to a test question like this, what I do if I'm looking for something like this, I may go down on my scratch paper and write down my memory aid, cold ice, just to kind of, I'm going to do a little mental workout before I go in and start answering questions. Okay. All right. Contract performance. 2 questions. Again, we're still staying in contracts. An assignor and an assignee. These are when contracts are assigned. You say, John, can you assign a contract? Yeah, absolutely you can. It's done every day. Let's take, for example, a lease. If I'm leasing property, right? I'm the tenant. I'm leasing I got a year contract, a year lease with the landlord. $1,500 a month. 6 months into my lease, all of a sudden, my job is not going good and I may be losing it. I need to move back home, whatever the case may be. I go to my landlord and say, hey, can I assign my lease? I get permission to assign the lease. You come along. You need a place. You like the place. I assign my lease to you. Okay. I'm the assignor. You're the assignee. Now, who's responsible for the lease? Is it you or me? Well, it's my lease that I assign to you. So you're under my lease that you're taking over. It's like assuming a loan for a house that you purchase. You're assigned my lease for the remaining 6 months. Then you're going to make out a new lease for yourself. But you're on my lease for the end of the year. So if you violate my lease, I still can be responsible. So you're primarily the responsible party, but I am also responsible if you can't fulfill my lease. The landlord can come back after me as the assignor. What's the only way that I can be completely eliminated of responsibility and liability? What's the term I'm looking for in contracts? Anybody know that term? You remember the term novation? Novation is a term that says I'm completely eliminated. In other words, you come in and you fill out a new contract. It's under your name. I didn't assign it. Novation means I am released of my liability of my contract. Okay. That term's called novation. It's a new contract. It substitutes an old one. So assignor, assignee. Okay. We're both still responsible. Okay. Now, when you sublease, I'm not assigning the whole unit. Remember, I'm moving out. I'm going home. You're taking over the whole 3-bedroom, 2-bath. Okay. Now, if I sublease, I'm going to say, hey, you know what, Mr. Landlord, I need help with this $1,500. I want to split it $750. So someone comes in and I a sublet or what's called a partial lease. In other words, I'm taking them in as a roommate. Okay. And we split it $750 a piece. So when I'm assigning a lease, all of it goes to you. Assignor or assignee, both responsible for the lease. Okay. If I'm going to sublease, that means I'm going to do a partial, or to subrogate. I'm going to do a partial lease where you're going to come in, or the individual will come in, and I'll rent out a bedroom, the kitchen, all that will be common areas. Okay. Know the difference between an assignment when it comes to a lease and what a sublease or a partial lease is. Okay. So 2 questions. Partial lease interest may be transferred by a lessee. This is a what? Okay. A partial lease is called a sublease. Okay. Very good. Now, the next question. Which of the following below is responsible for a lease that is assigned from a lessor to a lessee? Which of the following below is responsible for a lease that is assigned from the lessor to the lessee? Okay. Remember, let's go back and review real quick. Remember what we said about an assignment. I assign my lease to you. Who's responsible for that lease? You are, as the primary, but I am also responsible for the lease because you assumed my lease. You took over my lease. So if you don't fulfill the obligation of that lease, like paying rent or damage the unit, then guess what? The landlord can come after me too. So we're both responsible. Okay. Although you're primary and I'm going to be on the backside of it, I'm still going to be held liable for your performance of the remaining of my lease. So the question is, which of the following below is responsible for a lease that is assigned from a lessor to a lessee? Both parties are. Okay. Both A and B, the lessor and the lessee, are responsible. Okay.
For more practice questions, videos, and insight into the state exam, we encourage you to join our free webinar, How to Pass the Real Estate Exam Without Your Real Estate Book and with only 15 to 20 hours of study time. Get registered now at myrealestatetutor.com/exam.